who is involved in this case was 26 years old. This was a setup by the state of Tennessee where they solicited by advertising in a sex journal that someone was 22 and listed a phone number, and then had conversations after that. There was no sex act in this case. There was no touching in this case. There was an individual who appeared and made a comment one way or the other about, you look older than what the 16 you referred to in a text conversation. Because the 3913-309 in talking about trafficking for a commercial sex act, in our opinion, requires coercion or deception as one of the acts to be included as sexually explicit conduct, there is no proof in this record that Mr. Baylis did any of these acts. While Mr. Baylis may have patronized prostitution, and we would refer the court to the case of State versus Ashley, which is cited in footnote 2 at page 22 of the state's brief, where trial judges appear to be having difficulty with the way the legislature set out these cases for conduct. And in fact, Judge Freiberg had that difficulty. You can see it throughout his record, throughout his sentencing, throughout his rulings, throughout his reserved rulings, is how can we punish the same act as he saw it in 3 different ways. But we believe what he was referring to is the sexually explicit conduct, because we believe that trafficking for commercial sex act requires the acts of coercion and deception in addition to the sexually explicit conduct. Yes, sir. Do you have a question, Judge Witt? Or
I'm just thinking.
Okay. Because of that, and because the judge had that difficulty, we would ask the court to examine the record to give us an appropriate interpretation. Because if you look at the Ashley case and the facts of that case, the facts of that case are so much worse than what happened in this case. And yet that was found to be, by this court and by the agreement of the state, to be a Class A misdemeanor. Mr. Baylis is going to the penitentiary should the court not reverse this ruling, because the trial judge denied probation and sentenced him to the minimum for a Class B felony, 8 years.
And he has not started serving that sentence. He's not. I guess he's on appeal bond.
Yes, he is presently on appeal bond. Yes, Your Honor. He served prior to the time of a bond motion and the motion for new trial. He served a period of time because he was taken into custody upon conviction, and then he was released on a bond.
Thank you.
We would note that the bond is an ROR, Your Honor, which tells you the difficulty we believe that Judge Freiberg had with this case. We would also like to raise 2 other issues. One is the indictment in this case does not show that any witnesses were sworn in front of the grand jury. There is an easy way for this court to resolve that. When I went to law school a long time ago in Chicago, the state of Illinois required that a transcript be made of all grand jury proceedings. If we had a transcript by the rules or by court decision, we would not have any issues concerning whether or not witnesses were sworn or what witnesses were sworn, or whether or not the grand jury foreman properly swore someone in applying his signature to the indictment.
We know that given the mandate for grand jury proceedings being secret, there's not going to be a transcript.
Well, Your Honor, I understand that. There is that same mandate in the state of Illinois. but there is a transcript made should an issue arise of those occurrences. Otherwise, we have what the requirements say, that the grand jury foreman shall endorse and swear the witnesses, and he endorses that on the indictment. It was not done in this case.
Except we know from various judicial opinions that shall does not mean shall.
Your Honor,
in this area.
I am in a case where I don't know what coercion means, I don't know what deception means, I don't know what age means. So certainly to say that shall does not mean shall does not surprise me after these years.
I understand.
We would also ask, as a way of argument for the court, to look specifically at the argument that was made by the assistant district attorney in this case, which was, oh, by the way, why does he know the hourly rate? Anybody ever think about that? That does two things, Your Honor. That both implies that my client, Mr. Baylis, failed to testify, and he had a moment hearing and said he didn't want to testify. Two, it implies that he has been involved in prior criminal activity, which is totally improper. And third, Your Honor, which is the reason why we raise this, is the only source of this information could be the defendant, and he did not testify, as is his Fifth Amendment right. So we submit that in a close case, which we submit this was, that the state should not have been allowed to make this argument. We would reserve the remainder of our time unless there are any questions from the court.
Thank you.
Good morning, Your Honors. May it please the court. Abigail Renard for the state. This court should affirm the defendant's conviction for trafficking for a commercial sex act. Here, the defendant, by his own admission, believed that the undercover officer was 16 years old. He then proceeded to try to convince her to move from Sweetwater to Knoxville so that he could benefit financially from her provision of a commercial sex act. This evidence is sufficient to sustain his conviction. Moreover, the trial court correctly denied the defendant's untimely motion to dismiss the indictment.
Read for me the statute or the portion of the statute under which this man was convicted.
The defendant was convicted under Section A1 of the Trafficking for a Commercial Sex Act statute, which allows for conviction if the defendant attempts to benefit or attempts to subject the victim to from the victim's provision of a commercial sex act. And then with that is A3, which allows for, applies if the intended victim is a law enforcement officer.
Well, in your brief, and I'm a little bit handicapped because I left my copy of it with my notes on it in the back, but so I walked out here without it. But in your brief, you keep referring to that portion of the statute that talks about a minor victim as being, as that element is the defendant believes to be
Correct,
a minor victim. That's not what the statute says.
No, it is not explicitly what the statute says. However, the statute incorporates criminal attempt, which makes the defendant's subjective belief about the victim's age.
You think the attempt
correct
introduces the concept of believing she to be a minor victim?
Correct, because in that instance, it's the defendant's belief about her age that is the relevant inquiry, not her actual age. So had this been under, for example, A2, which does not incorporate the attempt language, I believe it talks about recruiting, harboring, transporting, any of those actions that don't incorporate attempt. In that case, I would argue that it would be the victim's actual age would be relevant. But in this situation where it's under A2 and the statute incorporates the attempt language, I believe the language is attempt to subject or attempt to benefit. In that case, it kind of places the defendant's belief about the victim's age in the center. And this court has held similarly with, in other cases, addressing, for example, the solicitation statute, which, uses kind of the same language. I believe it's attempt to induce in that statute. And this court found that it essentially incorporates the attempt language, which makes the defendant's belief about the situation, were the facts as the defendant believed them to be, he would have been guilty. And that's the same situation here, where if the defendant was correct and she had been 16, then he absolutely would have been guilty of trafficking for a commercial sex act. Here, his belief is what's relevant, and again, by his own admission, he believed that. Early on, when he responded to this advertisement on the escort site, she told him very quickly that she was 16 years old. He acknowledged that in the text messages. He kind of bemoaned the fact that she was 16 and a minor, claimed that she was putting her clients at risk, all of these things, but continued talking to her nonetheless. Then he started this kind of sales pitch about why she should move to Knoxville because she could make more money there. He told her she could make $250 to $300 per hour because there would be more clients in the big city, and he continued trying to convince her that she should move. He said, you need a sponsor, maybe I would want you to stay around for a while and help with day-to-day operations. Then he gets to the hotel, and
So far, everything you've described happened online.
Correct, yes. So they were
he hasn't laid
messaging-
eyes on her at this point until they get to the hotel. That's when he first sees her.
Correct. So then he sees her, he saw the photos on the advertisement, which were not of her. And they did not show her face. They were just pictures below the neck. So he arrives at the hotel and he walks in and says something about, "You're a young thing, aren't you?" And again, continues to kind of acknowledge her age and that he thinks she's a minor. And he says something along the lines of, "Oh, you're grown, aren't you? You have a fake ID, you do what you want." And the words, if you just read them, can sound like he's, arguing that she might be an adult. But if you watch the video, the tone in which he says them, he is speaking as an adult, talking to someone that he believes is immature and a minor. He's taking more of a patronizing, like, "Oh, you think you're very grown up, don't you? But you're really a 16-year-old. And again, she says in that interaction that she's 16. Then, after the defendant is arrested, he tells the officer who's interviewing him that she was 16 and that she was a minor. There's no real dispute here that the defendant believed she was 16. Despite that, he continued trying to get her to move to Knoxville, trying to convince her that she could make more money if she were in Knoxville so that he could benefit financially from her provision of a commercial sex act. Turning to the specific statute and the idea that coercion and deception are required, that is not what is required here. And the defendant's interpretation of this statute would essentially eviscerate a lot of what the statute is trying to accomplish. Under provision, the definition of a commercial sex act requires either that the victim is a minor or that there is coercion or deception involved. There's no requirement that if the victim's a minor, coercion and deception are required. That has never, this court has never held that. That is not what the statute says. And because the state proceeded under the A2 or A1, which incorporates the attempt language, it is enough that the defendant, again, as we discussed earlier, believed that the victim was a minor here. Coercion and deception were not required. To address the defendant's comments about State versus Ashley, I want to push back a little bit on the contention that the facts in that case were more serious than here. That case was a patronizing prostitution case where the state proceeded under an enhancement factor within patronizing prostitution, where if the victim is an actual minor, the state is allowed to proceed under that enhancement factor to have it charged as trafficking for a commercial sex act. However, in that case, there were no facts showing that there was any sort of trafficking going on. He was merely trying to patronize this woman who he, believed was an undercover, or believed was a minor, but she was an undercover officer. But there were not these additional facts of trying to get her to move to Knoxville, trying to get her to, so that he could benefit from her provision of a commercial sex act. Here it was simply a straightforward patronizing prostitution case, and in order to have the enhancement factor apply, the victim does have to be an actual minor. That is different from the situation here where the state proceeded under a different statute. The statute incorporates attempt when the patronizing prostitution statute does not. So there are sufficient differences here those are very different cases. And State v. Ashley certainly does not require a different outcome in this case. Turning next to the indictment issue, the defendant's motion to dismiss the indictment here was untimely. Under Rule 12b-2b, a motion to dismiss the indictment has to be filed before trial, and this court has interpreted that to mean earlier than the day of trial while the jury's waiting outside the hall. The defendant moved to dismiss the indictment on this ground the morning of trial. He had moved to dismiss the indictment on various other grounds around a month before trial, but he did not raise this ground until the morning of. He was too late, and the court properly denied the motion. But even without that, as you noted, Judge Witt, the statute itself, well, this court has held that the statute is directory, not mandatory, and the statute itself also explicitly says that the omission to endorse the names of the witnesses on the indictment shall in no case invalidate the finding of the indictment. And here that is exactly what we have. The only proof presented was that the one signature from the grand jury foreman was missing, and that is not sufficient to carry the defendant's presumption of regularity applies here, and without an affirmative showing that witnesses were not sworn, the defendant is not entitled to relief. Finally, turning to the prosecutor's closing argument in rebuttal, the prosecutor did not comment on the defendant's right to remain silent. During his rebuttal, the prosecutor highlighted that the defendant had texted the victim saying that she could charge $250 to $300 per hour in Knoxville. The prosecutor made a comment of, oh, by the way, why does he know the hourly rate? Anybody ever think of that? This comment the defense counsel objected, and the court overruled, finding that the comment was fairly related to a text message in evidence. Here, the prosecutor's manifest intent was not to comment on the defendant's right not to testify. He was not asserting evidence that could only come from the defendant. His comment was not related to the defendant's decision not to testify. He was drawing an inference for the jury that perhaps, given that the defendant's text established that he knew how much a prostitute could charge per hour in Knoxville, it established that perhaps there was a reason that the defendant knew that. He did not specifically speak to the defendant, ask him why he didn't explain himself, ask him to explain himself. None of these egregious things happened that would have, drawn the jury's attention to the defendant's decision not to testify. And the comment was also not of such a character that the jury would have necessarily taken it to be a comment on his decision not to testify. Again, the prosecutor did not directly comment on it, ask the defendant questions, ask him to explain himself, and the defendant argued during his closing argument that he did not engage in any sexually explicit conduct or do anything to encourage or induce the undercover to engage in prostitution. The prosecutor's reasonable response to that was to highlight what the defendant did say and highlight that he had been making a sales pitch to the undercover officer to get her to move to Knoxville. The comment did not implicitly or explicitly invite the jury to consider the defendant's silence or question why he refused to testify on his own behalf. And to the extent that this court disagrees, any error here was harmless because it was a single isolated comment. Nothing in the record indicates that the delivery was particularly remarkable. And the trial court had already instructed the jury that arguments of counsel were not evidence, that the state had the burden of proof, and that the defendant was not required to make a closing argument. If this court has no further questions on these or any of the other issues, we ask that you affirm the defendant's conviction. Thank you.
Thank you.
Your Honors, to respond briefly, it is interesting that in Ashley, where they address the patronizing case, the court talks about that if the child is actually less than 18 to the age of 14, then they could be prosecuted under this statute. But that's not what the state did in this case, because there is no actual age. The actual age is 26. And we would point out to the court, and I may be boring the court by reading the definition of commercial sex act, but that is referred to by reference in 3913-309, which is what the trafficking conviction before. It talks about Part A, any sexually explicit conduct for which anything of value is directly or indirectly given, promised, or to, or received by any person, which conduct is induced or obtained by coercion or deception, or which conduct is induced or obtained from a person under 18 years of age. There are specific definitions of coercion and deception, and each state witness in this case who had to do with the facts of this case was asked about each and every element of those coercion and deception definitions and said they did not exist in this case, and the person was not under 18 years of age. Or Part B, any sexually explicit conduct that is performed or provided by any person which conduct is induced or obtained by coercion or deception, or which conduct is induced or obtained from a person under 18 years of age. Again, all of those are defined, all of those were asked about under the facts. None of them exist in this case. The definition under 3913-309 says this: a person commits the offense of trafficking a person for a commercial sex act. The first reference in the statute to commercial sex act, which is what I have just read the statutory definition of. So you have to have a commercial sex act to traffic. Then says knowingly subjects, attempts to subject, benefits from, or attempts to benefit from another person's provision of a commercial sex act. The second reference to commercial sex act, which is specifically defined by statute. Part 2, recruits, entices, harbors, transports, provides, purchases, or obtains by any other means another person for the purpose of providing a commercial sex act. Again, the third time that there is a reference to commercial sex act, which is specifically defined by statute and which does not occur in this case. Now, Part 3, which they seem to rely on, and I want to emphasize what it says. It says commits the acts in this subsection A. So you have to commit the acts that are included in Part 1 and Part 2 to even get there. And each of those requires commercial sex act, which is defined by coercion, deception, or actual age of under 18. Says when the commits the acts in subsection A when the intended victim of the offense is a law enforcement officer or a law enforcement officer posing as a minor. So the acts in subsection A again require commercial sex act, which requires coercion, deception, or age. Now, there is only one case that this court has addressed this issue in, and that is the Ward case. And Ward is entirely different because that was a known prostitution ring where one of the victims testified about what she had been put through by the person who was running that ring. That is the only case
What was the name of that case?
Ward,
Ward?
yes, it's cited in our brief. And that's the only case that we could find where the court addresses this. And it is because the court referred to the acts of coercion and deception in Ward, which were clearly testified about by the victim in that case, that we say that this court must construe Part 3 when it says commits the acts in this subsection A to include the actual definition of commercial sex act, which is given to us by statute. And that this is shown by this court's language that is used in the Ashley opinion that came out in October of 2023, right as our briefs were being filed and referred to patronizing. Thank you, Your Honor.
All right, thank you. Thank you for your argument today, both of you. That concludes the morning docket. We'll be in recess until 1:30.